Here we go. Good morning. My name is Brenda Shaper-Pellinan, and I'm a planner with the Arrowhead Area Agency on Aging. I'd like to welcome you to, and thank you for joining us for today's session, Renters' Rights in the Market and Market Rate Housing. Before we start, a few housekeeping items. Today's session will be recorded to share on our Arrowhead Area Agency on Aging YouTube channel. I encourage you to subscribe to our channel so that you're able to keep up with the latest topics and additions to our video library. We are always looking for suggestions for future webinar topics. If you have suggestions for topics or for speakers, please send those to me and I'll share my email in the chat for that purpose. Please keep your microphones set to mute. Just a note, if you experience any issues with your bandwidth or audio quality, it may help to disable your camera. If you'd like, as I mentioned, you can enter your first name and your organization or the community that you're from in the chat box, what you're hoping to get out of today's sessions or how you found out about it. If you do have any questions during today's session, please feel free to either raise your hand or enter your question into the chat and we'll address those. We'll also take some time for additional questions at the end of the presentation. Another reminder, visit our Facebook page for more information about open mic sessions such as bending down to public programs and difficult dementia conversations. You can also check them out on our website at arrowheadaging.org. We are very lucky today to be joined again by today's presenter, Kristen Parendo. Kristen is the managing attorney of the Duluth Office of Legal Aid Service of Northeastern Minnesota and specializes in elder law and has for 20 years. She graduated from Mitchell Hamlin College of Law in 2001. Kristen lives in her childhood hometown of Esco, where she and her family raise cows and chickens for fun. Kristen, thank you for being with us today, and I will turn things over to you.
Thank you very much, Brenda, and hello, everybody. We can go to the next slide. So like Brenda said, I'm Kristen Parendo. I manage our Duluth office. There's my contact information. I put it on the front slide and on the back slide, so you'll have that. I encourage anybody to contact me if they have any questions or if you're a service provider and you want to talk hypothetically, I can do that as well. We can go to the next slide. Before we're going to talk about the topic, I just wanted to briefly show who we are and where we serve. We're in the northeastern corner of the state, cover 11 counties. The Title III Act allows us to serve seniors regardless of income and asset guidelines in 7 of those counties. There's our contact information. If you have people or you yourself want to call for help, call the 800-933 number. That's our intake line. That's the best way to get in. Another good way is to do an online intake. We're a nonprofit law firm, which means that we're not part of the government. We're a standard law firm, except we don't charge our clients for our fees. We get paid through different grants and grant streams, such as the Title III Older Americans Act. And our guidelines are we want to provide equal access to justice to the people in our area, which is hard to do sometimes, especially if you don't have money. So that's who we are and where we serve. Please call. If we can't help, we'll connect you to who is the next likeliest place to help. So we can go to the next slide. So today we're talking about market rate rentals. So this is standard landlord-tenant law. And I wanted to point out the main points in the process of renting and the different things that you might run into at those points, both problem-wise and remedy-wise and prevention. So we're going to first start out logically about the points of looking and applying for housing. And then once you find your housing, what do you do to secure the lease? What happens during your tenancy? What happens if you end a tenancy or the landlord ends tenancy? And then resources, and then finally credits and contact information again. So that's what we're going to cover today. It's a big topic. We have lots of slides, but I encourage questions along the way. It's a lot more interesting to get your questions answered than listening to me drone on. But that's what we're aiming to cover. If we don't, the slides will be there to provide the information as well. So let's get started. Next slide, please. So the first spot along the rental process is actually looking for housing. So this is stuff that we don't really see at legal aid, but it's like a threshold issue. If you're not successful getting an application in, or your history is causing you problems, these are the things that you can do to stop that from happening. So tenant screening. You want to check your tenant history for mistakes. It's similar to a credit report. You have a right to your report history. And if you have disputes about any of that history, you have a right to have them investigate it and put your version of the incident in their records. So specifically for tenant screening companies, you've got a right to the report, and they can't charge more than $9. But it's free if you've been turned down for housing within 30 days. So that's super helpful. And we'll see later along the lines that the landlord that you're aiming to rent from, they have to tell you the name of their tenant screening company. So if you know where you're going to rent, you can find that out easy. We can go on to the next slide. So if they turn you down, the landlord has to give you the contact information. So not only does it give you the front end before you apply, but after if you get turned down. So then what you do is you contact that company, and you got a choice. You can either ask for a phone disclosure of your history, or you can get a mailed copy. In my opinion, it's better to get a mailed copy because you have a record of it. Phone disclosure, you just get somebody talking to you on the phone at a time and place where you tell them that you're going to be available. It's easier to refer back to a paper copy. Because if you find that there's wrong information, then you can refer to that information easier to the company, because the company has to send a notice to everybody that they sent your information to within the last 6 months to tell them that it's wrong and that it's been deleted. So that's if they investigate and find that it's wrong. If they can't find that it's wrong, they have to let you put in your version, but they're not going to send that out to everybody that they sent in the last 6 months. It's only the people who got the wrong information. So next slide. So we have people that call us looking for help because they're not getting housing because of past evictions. So in those situations, we want to explore whether or not an expungement of the eviction record is a possibility. Because if that's the case and the court agrees, then the eviction won't show up when those tenant screening companies look for them. However, expungements are only available in very limited circumstances. So you have to either show that the court's decision to allow the eviction to happen was wrong in the facts. So if let's say you didn't show up because you didn't get the right notice because they had the wrong name of the tenant, so you never knew, so that's mistaken identity. Or you actually went to court and you won, but the record is wrong. So those are things you can get expunged. You can also get things where it's wrong in the law. So that's if you weren't served at all. So you can have a mix of reasons. So if you didn't get notice, you didn't show up and you lost by default. Maybe there was another good reason why you didn't show up. or you had a settlement agreement with the landlord and you did everything, and the landlord said in that agreement that they would expunge and they just didn't tell the court. That's another reason. The third reason is if the landlord building was in foreclosure and he moved out before you got the notice to vacate or the eviction summons and complaint. Those are the three reasons. So then you file a motion and the court will look at it. The court will grant it if it agrees that it's in the interest of justice to grant you the expungement and it outweighs the public's interest to know. So it's a balancing test. So in your motion, you'd want to tell all of the reasons why this eviction record is causing you problems. So it's kind of a discretionary thing for the court to do. We do have an expungement clinic at Legal Aid here. If you've got people who that would benefit, please have them call and we can get them set up with the expungement clinic and filled in. If it's expunged, then you take that expungement and you show the tenant screening companies, because once they know about it, they can't report it in the future. Well, you don't want to rely on them, on the system working, that they look again. You want to make sure that they know, affirmatively know that there's an expungement, so they don't report it. So we can move on unless there's questions about that. So you've looked for housing, now you've found it. So what do? These are the things that I recommend that people do. And I'm sorry that the bottom one cut off on that slide, but that's okay. I'll let you know what it says. So these are the things that you should do to avoid problems that we see at Legal Aid. So you want to take a look to see if the landlord actually has a rental license. Some communities have housing rules that the landlords have to follow. So in Duluth, for example, if a landlord does not have a rental license, then they can't legally rent an apartment and they can't legally collect money. So you should get all your money back if you have rented to somebody without a rental license in a community like Duluth, or they shouldn't be doing it at all. And you don't want to get into a rental relationship with that landlord. You find that out at the local building inspector's office. In Duluth, for example, it's called the Life Safety Department. They can also tell you if it's been condemned or if there's been code violations, so it's not habitable, because it's against ordinances to live in a condemned building. So it's not good to start a tenancy at one. So you want to check that out. Then if that all works out, all you do is you call and ask them to look at it at the address of the proposed apartment. Then you go and inspect the apartment. You want to look at the one that they're going to rent to you, not a different one. You want to look at the actual one. And if it's something that you're going to rent and you're at that point, then you want to walk through with a list and mark down the things that aren't perfect, or there's a little bit repair issues needed. You want to take photos. The best practices is if the manager would sign off on your list, but it's not a necessary thing. The best practices though, because then at the far end of the rental process, when you're getting your security deposit back, if you go to court, then you show them, well, this is what it was like when I moved in, and it's not any worse for wear beyond normal wear and tear, then you'll win your security deposit case. You also want to look to see if it's feasible for you. You want to look to see how much it's going to cost. Does the rent include utilities, cash, other fees? The one big thing is to look at if it's a shared utility meter or not. If it's shared, the utility bill can't be in your name, it has to be in the landlord's name. There's one small exception, of course, is if there's a very small usage outside of the apartment, like in the hallway, if there's just one light bulb, that's there, that might be an okay exception. But usually if there's a shared meter for more than one unit, it's got to be in the landlord's name. And to better allow the tenant to know if it's affordable, the landlord has to share the last 2 years worth of utility bills with you, so you can tell what's a likely electric bill going to look like and whether or not it's affordable. And then finally, you want to see if it's in foreclosure, because you don't want to rent in the foreclosed building. If the landlord fails to tell you, there's a $500 penalty that you can go to court to try to get. But it's a lot less hassle to not get into that hassle in the first place. So that's the background you want to do before you think, yeah, this might be a good place for me to move to. So we can go to the next slide. So here's where we get different fees. There's application fees, pre-lease deposit fees, and security deposit. So what the heck are they? An application fee is something where the landlord is asking for it because they want to get paid for doing the background check, basically hiring the tenant screening company. And that's tell you, so you can make a decision if you want to pay it or not. They have to tell you before you apply what is an automatic disqualification and what is the screening company that they're using. So you can make a decision about if you want to do some prep work beforehand to clean up any problems that might automatically disqualify you, or you want to submit any report from the screening company to make sure there's no wrong stuff in it. So if you decide to say, yeah, that's okay, I'm going to pay the application fee and do the application, the fee has to be reasonable, and it has to be given back if they don't do a background screening. Sometimes it's non-refundable, but you have to let you know that ahead of time. So reasonable is not defined in law, so it's just whatever the market will bear. But it should be, gosh, shouldn't be extravagant, but you know how that goes. Pre-lease deposits, that's where you like an apartment and you're going to put some money down to hold it. It's not the security deposit, and you do it before a background check and before the landlord agrees to rent to you. It has to be in writing. It doesn't have to be in a separate writing, so you want to look in the application as well, because that'll tell you when they have to give it back to you. So here's the important thing. If you turn down the apartment, you can't get your pre-lease deposit back. But if the landlord turns you down first, they have to give it back to you. So that's the timing issue there. So if it was a lot of money, I would wait until the landlord gives you a decision or not, so you get that money back. So we can go on to the next slide. And here's security deposits. So what a standard security deposit is for is to protect the landlord from damage beyond normal wear and tear. And this is something that's fought over quite a bit between landlords and tenants after somebody moves out. So you want to make a record of what the apartment was when you moved in with that list and take photos. And you want to get a receipt that you actually paid the security deposit, because when you leave, you're going to give them a request for it back, and you're going to calculate how much you're going to get back because you want to put in the 1% interest rate. And there's a form letter that you can use on lawhelpmin.org. And we'll cover more about security deposits as we go on to that end part of the process. But there's also pet security deposits. So this is to cover damage caused by a pet in a pets allowed building. So you want to get a receipt for that as well. or if there's a building that says we don't allow pets, but you have a service animal or a companion animal that your doctor says you need, they can't make you do a security deposit for the pet. So that's how that works. Any questions about that? We get a lot of clients coming in with landlords trying to evict people for having a pet. We can talk more about best practices about how to get a pet so you avoid problems. And I believe I have it later on in. We can go to the next slide. So also when you're looking at a potential apartment, there can't be any illegal discrimination. So if you find that the landlord is doing it or you think you might be discriminated against, you want to contact the Minnesota Department of Human Rights Disability Helpline, because you can file a complaint and they can investigate. So legal aid, we don't do discrimination claims. Restrictions with the Minnesota Department of Legal Discrimination is some adverse action that is taking, such as denying an application based on a protected status. And I listed the protected status here. So it's race, color, creed, religion, national origin, sex, marital status, sexual orientation, disability, the fact you have children, and the fact you get public assistance or rent subsidy. And in some cities, there's age. St. Paul has an age discrimination. So if you feel like you're being discriminated against on any of those bases, you want to document it, write down some notes about what was said, who was there, when it happened, and fine. And then we can go to the next slide. Let's say it's all hunky-dory. The landlord says, yep, you passed the background check. It's affordable to you. It's all licensed up. It meets all the codes. You're happy with it. You want to sign the lease. You want to hold off on that until you get a chance to really look at it and see if you agree with it. We get a lot of clients in a situation where, well, clients and landlords, they don't know what's in the lease. So you want to read it because there's a lot of good stuff in it and there could be some bad stuff in it. So you want to make sure if there's bad stuff in it, you can negotiate with the landlord to get it out. Sometimes they won't negotiate it, but if they don't and it's an unenforceable clause, it doesn't really matter because that won't be followed if it ever gets to court. But you want to make sure that you understand and agree with it because it becomes a contract once it's signed. And it's not really good defense to say you didn't read it. So I listed some of the ways clauses can be unenforceable. So anytime you see something in a lease that says you'll waive your right to something, that's a good indicator that it's probably unenforceable. Sometimes a lease will say a landlord can enter in to the apartment at any time. Nope, they have to have a business purpose or an emergency, or you give permission. Sometimes it'll say they can get a high late fee. Say, for example, $50 each time, and your rent is, let's say it's a lower rent, like $500, and that happens to be more than 8%. That's not allowed under state law. That would be usurious and not enforceable. Sometimes they will say that the tenant is responsible for paying attorney's fees if it goes to court. That's not the case if you win. The court, there's some statutes that also says that the winner of any court case will be awarded court costs. So those clauses aren't enforceable. Sometimes they say the landlord will repossess if you breach the lease. They can't do that either. There's no self-help eviction in Minnesota. They have to go to district court to physically remove a person. There's no acceleration clauses that are enforceable. So if you are in a fixed term lease, for example, that goes for a year, it might say if you breach the lease in a certain way, you have to pay the remaining months of the lease all at once. It's not enforceable. And then any automatic new rules or unspecified rent increase with no notice, that's unenforceable as well. So if the landlord won't take any of these out, it's not the end of the world because they're not enforceable. But it could give you an indication about how the landlord's going to be to deal with. So it might change your mind about renting from them. So we can go to the next slide. So we just touched on the two main types of leases. I wanted to put this in here so you know what you're dealing with because there's different rules for the different types of leases. So fixed term leases are where you sign for like a year. You move in on January 1st and the lease goes till December 31st of the year. So at the end of that type of lease, nobody has to give a notice to terminate unless it actually says so in the lease. So it just automatically ends. But if the landlord accepts rent after that, it automatically becomes a periodic month-to-month lease. So let's say if the fixed term lease says it's automatically renewed, the landlord has to give you a heads up on that towards the end of the year to give you an idea about whether or not you want to continue with the lease. So that's where it's important to actually read the lease to know what is needed as far as notice. So when we read a lease, that's the main thing that we're going to look at. What is the notice requirements to renew? What are the notice requirements to terminate? So that's the big one to look at. Another big clause that we are looking for is what we call an anti-waiver clause. So this is a clause where the landlord says by accepting rent, they do not waive their rights for any other action. So if they don't have that in it, we call that an anti-waiver clause. If they don't have that, then you have a legal defense if they accept rent after you breach a lease. So that's actually a good thing. You don't want to tell the landlord to put that in because that gives you a potential legal defense. So it's a waiver. So that waiver is allowed if the landlord accepts the rent after knowing of a breach. It's in essence them saying, I know about the breach, but I'm going to allow you to rent. That's a waiver. So that's another big thing to look for. Periodic leases have no set ending date. These are the ones that people know about as month-to-month leases. So they just go each from month to month to month. So in order to terminate those, the landlord or the tenant has to give a full rental month's notice. So where people get mixed up with these is where they say, I got to have 30 days notice. And they think that if the notice says it was dated, say, February 15th to be out March 15th, because let's say that's 30 days notice, that's not what the statute requires. You have to have the rental period notice. So if the rent is accepted on the first of the month, you have to get that notice to vacate prior to the first, and then you get the whole month after that before you have to be out. So it could be more than 30 days, calendar days notice that you actually get. So I have an example there. So if the landlord wants a tenant out by the end of February, the landlord has to give the tenant notice to vacate before midnight, January 31st. So that way, the tenant has a full rental period to live there and find another place. And then if the tenant doesn't move out after that, the landlord can't just come and kick somebody out. They have to go to district court and file an eviction action. And then the basis for that eviction would be fail to move out after receiving proper notice. So whenever we get somebody that comes in with a notice to vacate, we look at the date of it, when they got it, and what the period is on the notice itself. So we can go to the next slide. Alrighty, so let's have a breather from all these slides with the picture. So you've moved in, you signed the lease. What now? How do you protect yourself as you're living in your apartment? This is your home. We can go to the next slide. What you do to protect yourself is you know your rights and responsibilities, and you know the landlord's rights and responsibilities. We can go to the next one. So here we have good practices to protect yourself. So one of the best things a person can do is document everything. Speaking as a lawyer, documents win the day. If it just comes down to somebody saying something versus another person saying something, it's very hard for a fact finder like a judge to make a decision. And it's often based on credibility, and sometimes that's not fair. Documents win the day. So if you can document interactions in a very matter-of-fact way, keep them simple, where, what, who, why, when, how type of deal, like in a journal of some sort, that would be very good protection. And that goes across the board, not only in housing matters, just in life in general. It helps you in housing to prove retaliation, because if you can look back and say on February 22nd, I told the landlord that I'm contacting the building inspector to do an inspection, and then the next day he comes over and gives me a notice to vacate, that is retaliation. And you can, that you have the details where you can flesh out your retaliation case a lot better because you've got those notes. It also helps you to remember all of those things that you request. So those repair requests, or if you ask for reasonable accommodations from the landlord or anybody else. And it also gives you a place to keep receipts. So it's good to get a journal, maybe one with a folder where you can put receipts in, or a binder. I've seen people with binders and then the sleeves to put loose stuff in. We can go to the next slide. So another good practice is to remember that the fair housing laws apply to private landlords, not just subsidized landlords, apply to private landlords. So what this means is if you have a disability that's causing the landlord to ask you to move out, or say that you breached the lease in some way, or you didn't pay the rent because of it, if you can tie that disability to the problem and you have a plan, then you can ask for a reasonable accommodation in the lease rules and stay. It's the way that the federal law was written so that people with disabilities can successfully live in their home. This is probably the most powerful tool that legal aid lawyers have in housing practices. We can go to the next slide. But you actually don't have to be an attorney to use it. Anybody can. And there's no magic to it, really. You just have to use the term reasonable accommodation. Those are the magic words actually to use. And it can be used for any type of disability. People mainly think of these for physical accommodations, like if you needed grab bars in the bathroom, or different things for physical disabilities, but it's also for mental health disabilities. This is especially useful for breach of the lease cases that can be based on behavior. And if you have a doctor that can put in writing and testify that way or in person that that mental health disability caused the behavior, and that either there's a plan, a support system that can be put in place that can prevent that behavior to happen. Maybe it's adjusting medications, maybe it's getting an arms worker involved to help with some daily activities. That can be a reasonable accommodation plan. Excuse me. It does not have to be a traditional primary care doctor. It can be a psychologist, psychiatrist. It can be a therapist. Any healthcare provider that logically would have knowledge of that disability. We've used it lots of times. Behaviors, I'm just trying to think of an example that would be good. Well, one good example would be getting a termination based on hoarding allegations by the landlord or over cluttered housekeeping issues. If the tenant has mental health conditions such as depression or anxiety or something along those lines, the landlord, that the therapist can say it directly linked to that condition. That's a good indication that reasonable accommodation can help with the problem, and let the tenant stay and let the landlord concerns be addressed. So the conditions are remedied for both parties. It's really a good tool. So we can go to the next slide. The only reason why a landlord can't do a reasonable accommodation is if it's an undue burden on them, or it fundamentally alters how they administer their building. And it's fairly rare that that's the case. So you should definitely try it. And another thing about reasonable accommodation, sometimes landlords will say, well, we tried it and it didn't work. We're going to evict the tenant. The reasonable accommodation laws and case laws say the landlord has to try a different one if there's another plan in place that might be able to work. So you don't just get one shot at it and then you're done. If there's something else that can work, you're supposed to try it, unless it's an undue burden or fundamentally alters their business. So we can go on to the next slide. Finally, a good practice to always keep in your back pocket is if somebody ever makes a complaint against you as a tenant, you want to make sure that your version of events gets placed in your record with the landlord. And the reason is because a contemporaneous record is a lot more credible than one that you do later on. For example, if a landlord has a 3 strikes and you're out policy, if you get caught smoking on the premises in the apartment, if you get to the 3rd strike and now you say those other 2 weren't correct or were wrong complaints, then you don't, it's more self-serving. So if you put in your incident, your version at the same time that the complaint is made, it can have a lot more weight to a fact finder. And if the landlord will agree to it, ask for a meeting to try to explain it. Sometimes if their concerns can be addressed, they won't move to termination. So we can go to the next slide. All righty. So I put 3, I got the next couple of slides are tenant rights during the tenancy. These 3 ones are pretty important, and we see these a lot at legal aid, and I'll have another slide that has more. But these three are important. So when you're a tenant, you have a right to privacy in your own home. It's your home, it's not the landlord's. So you possess the premises, you control the premises. Evictions, when we get to it, those are all about who has the right to possess the premises. So that shows you that during your tenancy, you're possessing it, you control it. The landlord can't enter your apartment unless you give them permission to come in, or they have a reasonable business purpose with reasonable notice, or there's an emergency of some sort. So now, if there's an emergency, that's like if there's water coming through the ceiling, or there's somebody screaming or smoke coming out the door, something along those lines. They can come in without giving you notice. Other reasons, if they want to do a regular inspection, housing inspection, or the housekeeping inspection, or if they want to do put batteries in the smoke detector or something like that, they have to give you reasonable notice. A lot of times people say, well, don't they have to give me more than 24 hours notice? The statute does not define reasonable. So reasonable is whatever fits this individual situation. Oftentimes 24 hours notice, it will be reasonable, but it doesn't have to be 24 hours. It's whatever is reasonable. If you find that the landlord violates it, you could go to court and sue the landlord for it, and you can ask for $100 for each time. That's where you can see where documentation can be very useful, because you can, maybe you don't want to go to court right then, but then you find out that the landlord's coming in quite a bit and violating your right to privacy, then you can go back and use your documents to fill in your court papers. If the landlord comes in an emergency basis and doesn't have a chance to give you a prior notice, when they leave, they have to give you a written note that they were there. So that's another way that they might violate it. So that's that right. Another right is the right to call 911, especially if you're a victim of domestic violence or another victim of crime. A landlord can't retaliate against you for that. In fact, if you have an order for protection or no contact order against perhaps your person you live with, you can break a lease without being liable for the remainder of the lease. Also, if there's a fire, you want to call 911. Of course, the landlords want you to call 911. Sometimes where we see problems is if the tenant would call 911 for non-emergency situations, technically, like if they have a problem with a neighbor that's being excessively noisy. Sometimes in some communities, a police department will tell a landlord that those calls are becoming a nuisance and there might be a fine in the ordinances for the landlord. The landlord might get upset about that and on the tenant. Want to watch out for that. To avoid that problem, you want to use the internal grievance procedure with the landlord if there's problems with the neighbor. And that's going to be something like submitting written complaint notices to the management about somebody if they're being too noisy. Again, document things in your journal. Another right is the right to be living in a safe and habitable home. So part of the landlord's responsibilities is to keep it in good repair and up to the housing code and free of any house safety hazards and any pests. We're going to look closer at this at the next slide, so we can move to that next slide. So there's a few different remedies if the landlord's not doing those responsibilities. It depends on what kind of repairs are needed and what's the severity of the situation. For example, if it's an emergency, if the heat is not working, there's no hot water or no water, then that's an emergency tenant remedies action. But if there's other repairs that the tenants asked for and that just never hasn't been done, that's more along the lines of a rent escrow action. So that's like if appliances not working might be more emergency depending on the appliance. But if there's like a door that's not on the hinges on the interior, or there's a screen missing, or a sink is not draining properly, those type of things, or our rent escrow action situations. The best way to do it is to ask for a building inspector in your community to come out and do an inspection. And then what they do is they look all over the apartment and they will see if there's any code violations. If there are, they'll make up a work order and give that to the landlord with a timeline for them to fix it. So, and you'll get a copy of it. So you can then tell the landlord that these are the repairs that are needed. This is a building inspector's report saying that if they're not repaired within a reasonable time, I'm going to file the rent escrow action, for example. For emergency tenant remedies action, you don't wait for a building inspector because it's an emergency. But you do have to give the landlord at least a chance of fixing it. So you have to contact the landlord and say, if you don't fix this problem within 24 hours, then I'm going to file the emergency tenant remedies action. So in those situations, you're asking the court to basically force the landlord to make those repairs because they're not going to get paid rent until you do. And in the case of emergency tenant remedies, they also might be on the hook for your costs to stay somewhere else in the meantime at a motel and pay for your food costs and those sorts of things, the costs that you normally wouldn't have to pay for, but for having to not be able to live in the apartment. I want to touch on just a little bit about bed bugs. We get this problem coming up at legal aid on a fair amount of times. The problem is that sometimes landlords try to pass along the costs of bed bug treatment from the start, even though often in the lease, it's up to the landlord to keep the premises free of pests. So if that's the case, they're not supposed to be charging the tenant the cost for the bed bug repairs. However, if the landlord can prove that the bed bugs are in the tenant's apartment due to negligence of the tenant, they might be able to then successfully charge them for the bed bug treatment. Or if they just flat out refuse to do the bed bug treatment prep work and say, I'm not letting you in to do it, and the bed bugs get worse and they have to do more than one treatment, that might be a problem for the tenant. But if it's a case where they're treating the building and you come to your apartment, we're going to treat it and they're charging you, you want to contact us with that because it's likely that they're supposed to pay that. Very hard to prove where bed bugs come from. Sometimes people try to prove that because they got a secondhand furniture item, then that's the reason why. But even then, that's very difficult to prove. If you wanted to have better arguments, then I would avoid getting secondhand furniture in your apartment, just so you can say I haven't brought anything in. That could be the case. But it's a landlord's job to prove it, and that's hard to do. So that's about bed bugs. So we can move on to the next slide. So here is a list of a bunch of other rights that you have as a tenant. So the gist of these is that you have a right to notice before things happen. As you can see, you have a right to be notified that the rent's going to be increased. And that's usually a full rental period's notice. You have a right not to be locked out. We talked about not having utilities, other emergencies. Being locked out is an emergency, and it's also a crime if the landlord doesn't let you back in. That's where you want to call 911 and tell them that you rent there and the landlord illegally locked you out. If you can reach the landlord before that, great, but you don't have to wait. There is a lockout petition you could file with the court if the landlord doesn't let you back in. You have a right to a certificate of rent paid, so you get the tax credit. If they don't give it to you by the deadline, which is in January, I believe, you can enlist the help of the Minnesota Department of Revenue, and they have an affidavit that you fill out. You can get a substitute certificate of rent paid. The Department of Revenue's remedy is to fine the landlord, so that's how they can have some leverage there. You have a right to be free from retaliation. We talked about that earlier. If you assert your rights or you're complaining about something at the apartment, if the landlord then turns around and does something against you within 90 days of you asserting your rights or complaining, that's presumptive retaliation and that's a legal defense. After 90 days, it just means that you have to prove the retaliation. It's not presumptive. We talked about another right already. You have a right to a court eviction before being forced out. There's no self-help evictions in Minnesota. You have a right to know who your landlord is and where their address is in case you have to serve them anything. You have a right to the security deposit back or the reasons why they're not going to give it back to you within 21 days of you giving them your written moving address, your forwarding address, and gosh, I just had a brain freeze. So your forwarding address and that you moved out. So that starts 21-day clock. If they don't give it back to you or you don't agree with the reasons, then your right is to sue them in conciliation court. And we can talk about that more. You have a right to not have your personal belongings be thrown out right away after you move out. If you didn't get everything out, they have to store it for 28 days. They can't keep them hostage in lieu of paying rent or any other debt you owe. And you have a right to have peaceful enjoyment of your home. The landlord has to try to get rid of any illegal activities on the premises, such as illegal drugs, prostitution, gun crimes, things of that nature. If they don't, then you can sue. So we can go to the next slide. And then these are your main responsibilities as a tenant. Of course, you want to pay rent on time. I should mention, don't withhold rent in order to force a landlord to make the repairs. Then they'll just try to get you evicted for non-payment of rent. It's better to do the rent escrow action because you're paying the rent to the court and then the landlord can't make that argument that you didn't pay rent. Just like the landlord has to keep your apartment free of illegal activities, you have to do the same. Follow the lease rules. If there's damages beyond normal wear and tear, you're on the hook for them. It'll get taken out of your security deposit. If it doesn't cover those damages, the landlord's remedy is to sue you in conciliation court. Anytime you sue for the landlord or they sue you, you have to watch out for counterclaims. So if you've got a beef with the landlord, you could raise it in that action as well. Likewise, if you sue the landlord and you owe them money, they could raise that as a counterclaim. So you want to look at those risks before you file an action. Of course, don't disturb the neighbors. Give proper notice if you want to move, and don't allow illegal activities by other people. We're going to talk a little bit about that in the next slide about guests. We can move on to the next slide. We're covering quite a bit and we're doing pretty good. But if people have questions along the way, feel free to ask. So guests, So this can be a problem for clients at legal aid. Of course, it's your home and tenants have a right to free association to have people who they want in their home. But this right is limited if, for example, your guests disturb others or breach the lease in some way. The landlord has a right to say that's not good. And in fact, it could give you a notice to vacate or evict you for that. For the guest, you're responsible for the guest behavior there. So the best way to avoid that is to make sure the guests know what the rules are before they come over. If they don't follow them while they're there, have them leave. Sometimes guests stay overnight, and leases sometimes say that people can only have overnight guests for so many days. For example, 14 days. If it's longer than that, you have to get the landlord's permission. If you don't do that and somebody thinks that you've got somebody there, they're going to call them an unauthorized tenant or unauthorized person. And the landlord could give you a notice to vacate or just go to eviction right off the bat for breach of the lease. So sometimes people get the wrong idea. The way to prevent that is to not give people opportunities to get the wrong idea. So for example, if management's coming in to do a regular inspection and they see more toothbrushes, for example, it's always toothbrushes. They see more toothbrushes than match the number of people allowed to live there. They're gonna tell the landlord or the management about it. If you're getting other people's mail there, somebody's gonna see it. They're gonna make a report. So don't let people get mail at your apartment. Don't have more stuff than normal there, more toothbrushes than normal. Don't have extra. There's other people's stuff there that can be identified as another person's. So those are all things that we've seen. We can move on to the next slide. So here's a problem that we see a lot is when our clients have neighbors that are disturbing them, and then they go over there to try to have the neighbor quiet down, but sometimes that evolves into a fight, a verbal fight, or even worse. So here's a better way to handle a neighbor that's disturbing you. You want to don't go over to do self-help. You want to do the written complaint to the management. Keep a copy. You have a right to have quiet, peaceful enjoyment. Keep in mind, some person's idea of noisy might be different than another's. So sometimes it's helpful to have a witness. If it keeps on happening, maybe have the manager come witness it. But don't get into a fight that then can get you evicted. Sometimes tenants groups, and they might be able to have ways to resolve disputes between tenants, so you don't get involved with the management. So we can go to the next slide. Here we get to the exciting part as far as legal work, the end of the tenancy. This is where people get notices to vacate, or they give them, problems ensue sometimes, and then there may be an eviction in district court. So this is the stuff we're going to talk about now. We can go to the next slide. We're doing great on time. All right. So you can have a voluntary move out where you as a tenant want to move out. So that's moving out without an eviction. So depending on what type of lease you have, you might be on the hook for a lot of rent if you don't give the proper notice. So you want to go back to the lease and read what the termination notice requires. So sometimes it'll be a 1 month rental period notice. Sometimes it'll be more than that. Typically for fixed term leases, it might have a 60-day rental period. You want to make sure and give the properly. If you move out for a fixed term lease without doing a proper notice, you're technically on the lease for the remainder of the full fixed term, even if you're not living there. And people think that the landlord has a duty to mitigate that. They actually don't. They can just sue you in conciliation court if it's below, well, it will be below $15,000 for the rest of the fixed term periods, months rent. So it could be 3 months, could be 7 months, whatever it is, you could be on the hook for. So it makes sense to do the proper notice. You also don't want to get on the hook for any charges for damages beyond normal wear and tear. So that's where you want to clean it fairly well. And before you leave, you want to go through a walkthrough with management if possible, with a list if possible. And there's where you're going to mark off things that are damaged in some way. And then you can show, maybe management will agree that that's what it is. And you can take pictures. So then if later, after 21 days, you don't get your full deposit back, you'll have that as proof. And if you did a move-in, walk-in list with photos, you can compare. And it'll be easier for that judge to compare what if the damage is normal wear and tear or not. Also get a receipt for the return of the keys, so you don't get a fee for rekeying the apartment. We talked about this a little bit. If they don't return the deposit, you go to conciliation court. Beware of counterclaims. Before you sue, best practices is to send a letter saying, hey, I requested my security deposit. It's been 21 days. I want it. I want an itemization of cost, labor, and materials of the damages. You could also throw in some of the language of the statute if they didn't give you any indication of why they're not returning it. There's some civil penalties that you could let them know about. And then if they don't do what you want, then you can sue. Then you've built yourself a paper trail to help you in the proof department. So by way of standard proof for eviction cases and for security deposit cases, the standard is preponderance of the evidence. So whoever is trying to prove something has to prove it by preponderance of the evidence, which it typically means a little bit more than 50%. So it's not a very high standard. It's the lowest standard of proof that we have. But you still have to do it if you're trying to prove that the damages was not beyond normal wear and tear. The landlord has to prove an eviction case. We'll get to that. We can go to the next slide. Here's ending the tenancy when it's not voluntary. This is where the landlord wants you out and is filing an eviction action in court. So the way it happens is for private landlords, they can give you, if they want, they can give you a notice to vacate. They don't have to give you a reason. It just says, we're ending your tenancy, move out by X date. If that meets the notice period requirement, that's fine. And then that, if you don't move out, that's a valid basis for them to file an eviction action and win. So you can see where those notices are very important to look at, because when we get these cases, we're going to look at that notice. We want to know when they got it, what that notice period is. If it's improper, then we're going to ask the court to dismiss the eviction. Another ground for eviction is non-payment of rent. So the landlord does not have to give a notice about this. They can just go to district court and file a complaint. However, they could give a 14-day notice if they wished. A breach of, before I go on, non-payment of rent case can be remedied if the tenant pays all of the rent owed plus the landlord's court costs and service fees. Those court costs and service fees are around $400. So it can be pretty pricey. So that's why if you're having problems paying the rent, you want to try to work something out before the landlord finds. Then they got more incentive to continue on with an eviction. They've spent more money on it. The third main ground is a breach. So if you've breached any of the clauses in the lease, then that can be a basis. So these are damage to the unit, harassing somebody, smoking, doing anything that's not allowed in the lease, having somebody there that's not supposed to be there, that sort of thing. So when we get somebody that has been served a summons and complaint for an eviction, we want to look for defenses. So at each stage of a eviction, there's a potential for defenses. So we're going to ask, did you assert your rights in the recent past? Did you ask for something that wasn't provided or was provided? Did you make a complaint against anybody? Anything like that. So we're looking for retaliation defenses. We're looking for whether somebody asked for a reasonable accommodation that wasn't followed. I think these are in my next slide. We can move to while I'm talking about it. So if you didn't pay the rent, but you can tie that to disability, where you didn't couldn't get out of the house or something, then that's a reason for a defense. Or if you missed an important notice from the landlord and a mental health reason meant that you're not good at opening mail, a reasonable accommodation could be an armed worker to open the mail. And if the landlord didn't accommodate that disability, that can be a defense to the breach of lease case. Other defenses are maybe they're just plain wrong. Maybe there's the breach is wrong and somebody else did the problem. Well, we're going to be talking about all those things. We want to look for any technical ways to get it dismissed, like the notice requirements are wrong or the service requirements weren't followed. For example, that's the next slide. So when you're served with a summons and complaint, it has to get to you before 7 days before the court hearing. If it's less than 7 days, that's a way to ask for it to be dismissed. So there's all kinds of little things like that. If the landlord is a corporation, you can ask for it to be dismissed if they're not represented by an attorney. But that typically has to be done later in the process, not at the very start of the eviction. So this whole thing happens fast. Evictions are summary actions, and it can be all done as early as 3 to 4 weeks from the time you get served. So that's very fast. So you want to do everything you can to slow it down. You want to ask for help from people like us at Legal Aid early, because there's more we can do if we get involved earlier. So it's even better if there hasn't been an eviction filed yet, because then we can ask for more time to move perhaps, or do reasonable accommodation work where find solutions to stay without having an eviction. But let's say an eviction's been filed, we can perhaps look for ways to negotiate for what your goals are. If your goals are to stay or to leave, there can be different ways to handle that. Oftentimes, people will want to move or they don't have a real good legal defense and it's just not in the cards to stay. We can often negotiate for them to have more time to move and get expunged if they move in time. If we give the landlord something. So what the landlord gets when you settle oftentimes is if the tenant doesn't do what's agreed upon, they don't have to go back and refile and pay another $400 and do all that work. They can just go to court and get an immediate writ of recovery. So they're not out any more money. It's just the fact of them getting more time. So those are some of the things that we can ask for, and anybody can ask for. You don't have to be an attorney to do negotiation work. So we can go to the next slide. So here we go. This slide is if you can't settle it, go to the trial. If you don't show up, you're going to lose by default, and the landlord can get an immediate writ of recovery. And then you're just losing out on more time, because if you don't win, you can ask for 7 days under the statute to move. So if you go and you know you're going to lose, it's worth it to go, because you're going to likely get the 7 days to move instead of not having those 7 days. So you can extend that more time, slowing things down, give you a chance to move to a place to be in, at least temporarily. So the landlord has to wait for however long the court says that they have to wait. If it's immediate, they don't have to wait. If it's 7 days, they have to wait. After the 7 days, they ask the court for the writ of recovery. So they get that piece of paper, then they have to give it to the sheriff. The sheriff will post it on the premises, and then 24 hours has to go by. After 24 hours, the landlord and the sheriff can then come over and physically remove the tenant from the apartment. So if you are at trial and you know you're likely to lose, what you want to do after asking for 7 days and you leave the courtroom is you're going to want to pack up your important things that you can't live without in the short term. Your medicines, important papers, clothes, things like that. Things that you have to have no matter where you are. If you win, of course, you get to stay. We can go to the next slide. If you move out, whether it's eviction or not, let's say you've been evicted, the landlord and the sheriff's been there and you're physically removed and some of your stuff is still there, the landlord has to store it for 28 days. And they have to give you an opportunity to get it back. If your stuff is still on the premises, you have to be let back on the premises within 24 hours to pick it up. It's 48 hours if it's stored off premises. So technically the landlords have to do an inventory of your belongings, so you know what's there. Of course, they can store it off premises. After the 28 days, the landlord can sell the items and use the proceeds to either pay off anything you still owe the landlord. If there's anything left over, they have to give that to you. If they don't want to do a sale, they can throw it out. And there's nothing you could do about it after 28 days. If they do the sale, though, they have to give you about 2 weeks notice before the sale, so you can be there. That's pretty cute. Or you can try to get stuff before the sale happens, or have people buy it, I suppose. If you haven't been able to get it, that doesn't make sense. You should just go get it. If the landlord violates any of these notices, then you sue in conciliation court. This isn't ideal, of course, because the value of personal properties after you get them is basically garage sale value, unless you have receipts for things. So it's best to make a demand, do it in writing, and then go get it before it's lost. Let me go to the next slide. So because I do elder law, I wanted to talk about what happens if a tenant dies, the way of ending a tenancy. So, but this notices still have to be given if the tenant dies. Either the landlord himself or herself, or the tenant's estate can give 2 months notice of termination. So this is especially important if there's a fixed term lease that the tenant had. So this way you're limiting the estate's liability to 2 months rather than the rest of the fixed term. This right can't be waived in the lease. So it's not enforceable if somebody wants you to waive it. If the deceased tenant owes money to the landlord can't require it from the family. They can only require it from the deceased estate. So they might have to do an estate claim in probate if there's going to be a probate. The law allows the landlord to let the family in or the tenant's personal representative in to remove the belongings or clean up the unit. Sometimes what we do to help prevent problems, because landlords can get nervous about being sued by family members if there's a dispute about somebody's stuff. What you can do is sign an affidavit while you're alive saying, I'm not going to probate if I die, and I give permission for this person to enter my apartment and clean it out. So that gives clear indication that permission was given to a certain person, and that can ease a landlord's concerns about that. The law does give the landlord authority to let people in that are not the tenant. So we can move on to the next slide. So here we're doing great for time. I have a couple of slides for resources, and then we can have some questions. So here's legal aid service. That's where I work. That's our intake line, and online you can do an intake as well. This next one, lawhelpmin.org, is great. They have all sorts of fact sheets. They have fillable forms where you answer questions and it generates different forms for many different legal topics. And they can connect you to legal services if you're outside of our area or there's another service that you may need. 211 is great. Great to call them first too. They can connect you to all sorts of services, legal or otherwise, especially financial assistance, crisis response, eviction prevention. So those are very good resources to have. Next slide, please. I would be remiss to mention these two great sources, especially Homeline for all renters. They are experts in Minnesota landlord tenant law, and they have a hotline that they answer, and they also on their website have some forms as well. If you are in a mobile home, a manufactured home, this Minnesota All Parks Alliance for Change website is indispensable. It has all the different extra rights that mobile home tenants will have. Typically, it's more notice because if it's your home that you're renting a lot, logically it's going to take you more time to move that mobile home. There's a lot more notice requirements, things of that nature. Then we can go to the next slide. I want to say thank you to Brenda for all your help with putting this series together, and for the Minnesota Board of Aging and the Area Agency on Aging for funding our senior project and our different projects at Legal Aid, and credit for the Slides Carnival for the template. And final slide is my thank you to all of you for attending today. And here's my contact information again. The number there is my direct phone number. It accepts text as well. And there's my email address. Like I said, if you've got questions and you just want to talk hypotheticals, I'm happy to do that, because that can often solve questions too. Or if you want to become a client, call our intake line. Or if you have a question about whether or not you want to see if we make a good situation for a client, you can contact me too. Whatever works for you. So thank you again.
All right, thank you, Kristen. Thank you for all of that. I think that was a very good overview in terms of, and very comprehensive and very good on time. So hitting all of the bases. Are there any questions before we sign off for the day? Again, in the chat, and I've got Kristen's contact information, both phone and email. You can also reach out to them at Lead Services of Northeastern Minnesota. We're going to have some other sessions coming up. If you work with clients who might be applying for public programs, or you've got family who might be applying for public programs, or you yourself may think you might need to apply for public programs to help with long-term care costs. In the future, we're going to have a session on March 15th on spending down to public programs. We're also going to have another one coming up in April looking at some of the issues surrounding kind of the difficult conversations with dementia. So questions about legal questions, questions about driving, questions about what type of things to be thinking about on when someone has received a diagnosis. So be looking for that. You can follow us on Facebook. We've also got our YouTube channel where you can watch videos of our previous sessions, and we will have this one up there. I will get an email out to everybody who registered for today's session with a link to the video as well as a survey on the presentation. But other than that, thank you for joining us today, and thank you, Kristen, for being here with us and sharing your wealth of knowledge. I know that this is going to be an extremely helpful resource, this video, for folks who our senior linkage line folks talk to, and to be able to give them that as a resource, and then gonna also connect them to you. It's going to be a really helpful thing. So anything else?
Thank you very much. Have a great day.
All right, thank you. Stop recording. End session.